but can everybody hear me? Okay. All right. And I also feel like I have to say, I don't normally like loom over people like that, but she needed to be able to be picked up on the mic. So that's why I was standing that close to her. It wasn't like something creepy or anything like that. All right, we're going to try to talk. I'm going to try to talk about as much stuff as possible, as quickly as possible to cover all of this in an hour. So if I move too quickly, you can tell me to slow down. But I'm going to try to move quickly. We're talking about the new Roberts Court. We're really entering a new era at the Supreme Court, like in a really big way. So before we get to actual cases, we're going to talk a little bit about court history so that you can kind of understand the context of what's going on and what the new era really means, right? So most of you have either heard, maybe some of you remember the Warren Court. The Warren Court had 5, maybe 6, sometimes maybe even 7 pretty strongly left-leaning justices. It was very much a left-leaning court. There was no swing justice on the Warren Court. It was a liberal majority and known as a liberal court. And it was that way for, I mean, Chief Justice Warren was on the court for about 15 years. But really, it kind of that era kind of started before Chief Justice Warren even took over the court. So the liberal court had gone for a couple decades. And then a bunch of stuff happened. LBJ decided he's not going to run for re-election in 1968. And Chief Justice Warren decided to resign from the court deliberately to give LBJ the opportunity to appoint his replacement. The Republicans in the Senate didn't like that idea, said we can't do court appointments during an election year, which might sound familiar. And LBJ appointed Abe Fortas, who was already on the court, to be the new Chief Justice. And so Justice Fortas was going to be the chief, except the Republicans didn't want this to happen. So they started digging and trying to oppose Justice Fortas's nomination. They came up with some pretty potent ammunition. There was some financial improprieties, some other ethical improprieties. And in fact, Justice Fortas was forced to resign from the court because of those improprieties. And then Robert Kennedy was assassinated, probably the favorite to win the election, but then was no longer available to win the election. And so Nixon wins, and he walks in the door to the White House with 2 vacancies on the Supreme Court because Chief Justice Warren has resigned, Justice Fortas has resigned, and Nixon gets 2 seats. Within a year, 2 more justices on the Warren Court, what used to be the Warren Court, die within a month of each other. So Nixon, in his first 2 years of office, gets 4 Supreme Court appointments, and the Warren Court is long gone. We now have the Burger Court. Nixon appoints 4 right-leaning justices to the court, including Chief Justice Burger. And we move into a new era because the Warren Court's behind us, right? But the new era is what we could call the swing justice era, because what happens is in the mid-70s to late 70s, Justice Powell emerges. Justice Powell is a moderate conservative appointed by Nixon. He kind of emerges as this center swing justice in the mid to late 70s. And the court's fairly evenly divided by the remnants of the Warren Court and Justice Blackmun fairly quickly, he was appointed by Nixon. He was a moderate conservative, but he fairly quickly starts drifting to the left and joins the left side of the court. So we have this swing court with Justice Powell in the middle as the swing justice. And then Justice O'Connor is appointed to the court in 81, maybe 82, somewhere around there. And Justice O'Connor is a little more conservative than Justice Powell, and she becomes the new swing justice on the court. So the center of the court shifts a little bit further to the right, but we still just have a swing justice who can go either way in those closely divided 5-4 decisions. Justice O'Connor is the swing justice for about 20 years on the court. Again, with Nixon's appointments and the new swing justice era, we have a conservative leaning court, but not a really staunchly conservative. It's a pretty moderate conservative court with a swing justice. When Justice O'Connor retires in 2001-ish, 2002, somewhere in there, Justice Kennedy emerges as the new swing justice. He's a little more conservative than Justice O'Connor was. So again, the center of the court moves a little bit further to the right, but still, yes? Oh, you're looking for the waiter, sorry. That's not me. So Justice Kennedy is a little more conservative than Justice O'Connor, but is still very much a swing justice. So if you look at Justice Kennedy's tenure on the court, if you look at, say, 15, 20 years of being a swing justice, it's not 20 because he retires in, what was it, 2018, I think. So roughly, say, 15, 16 years as the established swing justice. If you look at his votes in the 5-4 cases, he votes about 60, 65% of the time with the conservative side and about 35 or 40% of the time with the liberal side. So pretty legit swing justice, right? But again, still tilting conservative. What we then get is in 2016, as many of you remember, Justice Scalia dies somewhat unexpectedly. President Obama tries to appoint Judge Merrick Garland to the court. This would have been the first time in 45 years that there were 5 left-leaning justices on the court, right? It was a big deal, which is why, again, the Republicans in the Senate didn't want that to happen and said, again, hey, we're not having any of this going on in an election year. They did try to do some digging. There wasn't much to dig up on Judge Garland, so they just opposed it just because it's an election year, right? And they succeeded. Now, if Judge Garland had become Justice Garland, it would not have, we still would be in the swing justice era, right? We still would have a fairly equally divided court, and a swing justice would have been either Garland or Breyer. I tend to think Breyer probably would have taken on that role as a swing justice. He tends to vote with the conservatives on a number of issues, particularly like criminal sentencing cases and stuff like that. So I think Breyer would have been the new swing justice if Garland had made it onto the court. But in some issues, it would have been Garland himself. He's also a very moderate left-leaning judge. So, but Garland doesn't make it onto the court. Instead, his nomination is blocked. Trump is elected. Trump appoints Justice Gorsuch. Justice Gorsuch is a lot like Justice Scalia. So nothing really changes on the dynamics of the court. We still have this equally divided with the swing justice, Justice Kennedy in the middle. And then what happens is, in 2018, we start to get the emergence of the new era. 2018, Justice Kennedy, the swing justice for the last 15, 16 years, announces his retirement. Huge deal, right? The swing justice is leaving. President Trump nominates and appoints Justice Kavanaugh. Justice Kavanaugh is not a swing justice, right? He's very staunch conservative. So we no longer have a swing justice. We now have a solid 5-justice conservative majority. And then last year, as many of you, I'm sure all of you will remember, Justice Ginsburg passes away. Justice Ginsburg is replaced by Justice Barrett. So we now have 6 strong conservative justices on the court. This is very much the Warren court, but for the right instead of the left. It's the swing justice era is gone. And this is the new era that we're walking into. This is the term that we're going to talk about, which is last term, not the term that's going on right now, but the term that ended in July. That's the term we're going to focus on. But this term we're in right now is the first full term with this new 6-justice conservative majority. So it's really the new era begins this term. But last term, Justice Barrett was there for most of it. So we see a little bit of where the court's going from last term. And so we're going to talk a little bit about that as we go through the cases. But she did miss a handful of cases. Now, I'll remind you, last year was an election year, but the Republicans in the Senate didn't have a problem with filling that seat during an election year when it was the person they wanted. But they weren't quite fast enough. She didn't quite make it onto the court. There were a handful of cases she did not get to participate in. So we don't have a full term with her on the court until now. But we still are into this. This is the new era, and that's kind of the historical context so you understand the significance of this new era. Swing justices no more. We can talk about a middle justice, but that doesn't really make a lot of sense, but we still talk about it for some reason. But that's what's going on. There's a lot of talk about court packing and other reforms, right? That adding justices to the court, adding or creating term limits, things like that. I'm not too convinced that any of that's really going to happen. I do think the biggest impact from all of that talk is that it might scare some of the justices into trying to be a little bit more moderate in what they do because they don't want things to change at the court. So maybe the rhetoric will have some influence on the court in what they do, but I don't think we're going to see much happen in terms of actual reform with the court. Personally, I think term limits would be a great idea, but I don't think it's going to happen. All right. As far as actual numbers from the last term, so the court gets about 8 to 10,000 cert petitions every year. It takes about this many cases. So again, a little historical context. The court used to decide 150, sometimes close to 200 cases per term. But in the early 1980s, Chief Justice Rehnquist brought that, the mid 80s really, brought that down to about 100 cases per term. So the court was deciding about 100 cases per term. And then when Chief Justice Roberts took over, that came down even further to 85, 90. Actually, it started creeping down toward 80, then down even maybe towards 75. And then we got this one year where they decided like 67 cases or something like that. And everyone is like, what in the heck? It was the lowest total since the Civil War. But we thought, well, maybe that's just like a fluke. And the next year it did creep up back to like 70, 72. But now we're back down to this. This now is the lowest number of cases the court has decided since the Civil War. And that's with getting 8,000 to 10,000 petitions. So it's significantly below 1% chance of getting your petition granted at the court. And this seems to be the new normal, 70 or fewer cases every year at the court. By the way, it coincides with opinions getting longer and longer. I think they have more time, right? We're deciding fewer cases. Let's write some more about it.
Has the 8,000 to 10,000 been pretty consistent?
Pretty consistent. It used to be really consistently 8,000, but then it's spiked enough times where now I tend to say 8,000 to 10,000. 8,000 was pretty consistent every year, but I say 8 to 10 because there have been some years where it's kind of spiked a little bit. All right, so I mentioned that there's a middle justice. This previous term, Justice Kavanaugh, for the people who watch the stats on these things, the justice who was in the majority the most number of times, that's going to be the middle justice, because anytime the court splits, if they're still in the majority, they must be in the middle of where the court is. Justice Kavanaugh was in the majority 97% of the time. That makes him the middle justice. But Justice Barrett, Justice Gorsuch, and Chief Justice Roberts were all like 95, 96%. Like they're all in the majority most of the time, mostly because they have a 6-justice majority. So the conservative justices are going to be in the majority most of the time. And Justice Kavanaugh, Justice Gorsuch, and Chief Justice Roberts are the 3 who are most likely to ever vote with the liberal side of the court. So they're going to be the ones who are probably have the highest percentage of being the middle justice. Justice Barrett, we still don't have enough information on her. Last term is not a full term for her because she missed a few cases. And so it's hard to say where she's going to be. Again, I don't think the middle justice really means anything. This is how we start to see the way the court is shifting. For, I would say, at least 15 years going back, there have been about 25% of the decisions being issued are 5-4 decisions, right? Where the court is split equally 5 to 4. And it's been about 25% for, I'd say, at least 15 years. This last term, it wasn't around 25% anymore. It was only 15% of the cases were 5-4. And the reason for that is now for the liberal side of the court to get 5 votes, they have to get 2 of the conservatives to join them. So that's going to be happening a lot less frequently. We can see the difference is made up in the 6-3 decisions. About 10% of the cases were decided 6-3 with the 6 conservatives in the majority. So we already, just last term, even though it's not Justice Barrett's first full term, we already see the shift in the court. We're going to have fewer 5-4 decisions. There's going to be more 6-3 decisions because the court just isn't really equally divided anymore. All right, so moving on to actual cases. The first case is an interesting one because it kind of shows a little bit about, illustrates a little bit of the shift at the court, and it's just an interesting issue. This is it's a criminal case. So the Sixth Amendment right to a jury trial it's in the federal constitution, and it's a federal right, and it's well established in federal criminal cases that you have a right to a jury trial. But the question that arose here is there were 2 states, Louisiana and Oregon, who in state criminal cases did not require a unanimous jury. And so the challenge was brought that under my Sixth Amendment rights, I have a right to a unanimous jury, and the state court is bound by the federal right. And the question really is, it was an incorporation question. Is this Sixth Amendment right to a unanimous jury incorporated against the states so that the right applies in state criminal courts, right? And the court in this Ramos case said, yes, there is a Sixth Amendment right to a unanimous jury under the federal constitution. It is incorporated against the states. So Louisiana and Oregon, you are violating Sixth Amendment rights by allowing criminal convictions without a unanimous jury. That's the Ramos case. That was decided in 2020, and it was a 6-3 majority with Justice Gorsuch writing the opinion. And Justice Gorsuch relies heavily on originalism for this opinion. He says, this is a right that was well recognized from, the original days of the founding and et cetera, et cetera. And the court says 6-3, it is a right. States can't do this. The Edwards case comes up. This is what happens when you have something like this in criminal cases. What about all the people who were convicted previously with non-unanimous juries? So the question is that retroactive? Is the Ramos case retroactive for everybody who is convicted? Now, if you read Justice Gorsuch's opinion in Ramos, this is an original right from the founding, right? So everyone who was ever convicted with a non-unanimous jury, their right that existed from the founding has been violated. So you would think this would be retroactive, right? But the court in Edwards, so I got to back up and tell you this. For retroactivity, the court looks at, was this a procedural right or a substantive right? This is how the court decides retroactivity. If it's a procedural right, procedure can change. So if it's just a procedural right, procedure can change, and we're not going to make that retroactive. It's just going forward. If it's a substantive right, though, that's something that theoretically existed for all time. And so a substantive right has to be retroactive because it always was a right. Now, again, if you read Ramos and Gorsuch's opinion, it sounds like this is a substantive right to a unanimous jury. But the court in Edwards, 6-3, and it's the 6 conservatives against the 3 liberals on the court, says, no, this is not retroactive. It's a procedural right. The jury, the makeup of the jury and the unanimous jury or the non-unanimity of the jury, that's a procedural thing. So this is not retroactive. All those people who were convicted previously, they don't have a claim for overturning their conviction. That's an interesting shift. And what's interesting, I think, about it is you have the conservatives who joined the majority in Ramos who like the originalism of the substantive rights that go back to the founding. And then in Edwards, you have the conservatives in the majority who, for different reasons, they don't like criminal defendants bringing claims to overturn their convictions. So it's you have conservatives, strong conservatives in the majority of both cases, but for very different reasons. Pretty interesting case, and starts to show, again, a little bit of a shift in the direction in just a year. All right, moving on. Standing. Hopefully everybody's somewhat familiar with Article 3 standing. The basic idea behind standing is you have to have an injury to bring a lawsuit, right? If you don't have an injury, you don't have standing to bring the lawsuit in the first place. So one thing that's interesting about standing is both conservatives and liberals will rely on standing when they don't want to decide a case that involves issues. If they want to punt on a case, they will say, well, maybe there wasn't standing, right? So articles have been written about this, about what they call closing the courtroom doors. And there are a number of doctrines that have been used to basically make it harder to bring lawsuits. Standing is one of them. Jurisdictional issues, lots of jurisdictional issues, immunity, governmental immunity issues. There's all these different doctrines where the court has used immunity, jurisdiction, standing as basically a way to make it harder to bring lawsuits. On standing, like I said, both conservatives and liberals will do this. They'll say, you know what, there's a standing problem here, and it's really, if you read between the lines, it's really they don't want to answer that question. So this case raises a really interesting standing question about the plaintiff had sued for a violation of First Amendment rights, but there were no economic damages from the violation of those speech rights. And by the time things had proceeded, there was no basis for like any kind of injunctive relief or anything like that. The only thing the plaintiff had was just, hey, my right was violated, and maybe give me nominal damages of $1 or something like that. But really what I want is just vindication that my right was violated. I don't have any economic damages. I don't have any basis for injunctive relief, but my right was still violated. And the question is that enough for standing? Like, do you have a real injury here to have standing to bring this case? It was a very interesting question because the direction of standing doctrine has been toward narrowing standing, right? We're going to make it harder and harder for people to have standing. And this case is saying, I got nothing except just my right was violated, but I wasn't harmed economically. I don't have injunctive. I got nothing, just this wasn't okay. Everyone would have thought that the direction standing doctrine was going would be that you don't have standing here. You don't have the kind of injury that gives you standing. But the problem is this is about a constitutional right, right? And we really would hate to say the violation of your rights is not enough to bring a lawsuit. So the court says 8-1, yes, this is enough to have standing. A violation of a right, even if all you got is nominal damages, that's enough of an injury to give you standing. Justice Thomas writes the majority opinion. Any guesses who the lone dissenter is? Surprisingly, to some, maybe not so much to others, Chief Justice Roberts is the dissenter. Chief Justice Roberts might be the biggest standing hawk on the court. He might be the justice on the court who is most willing to narrow standing for people to bring lawsuits. So really interesting standing case. I will mention real quick, I have a standing case right now at the Fifth Circuit. It's got Supreme Court potential because it raises really interesting standing questions. The party on the other side is suing for damage to property, but there's a big question about whether the party actually owns the property. So the question is, can you sue for harm to property that you don't actually own? Do you have standing for that? That's an interesting question, and it hasn't been squarely answered by anybody. So standing is a really interesting area of law. No one can tell you what the law actually is on standing because, like I said, most of the time it's just, do we want to hear this case or not? And if we don't, then you don't have standing. And if we do, then, oh, you do have standing. All right, moving on to another big doctrine. I mentioned jurisdictional issues as another way that the court has done this sort of close the courtroom doors sort of thing. Personal jurisdiction, if you remember international shoe, right, and the minimum contacts, and there's this distinction between general jurisdiction versus specific jurisdiction. General jurisdiction, this is for if you want to sue an out-of-state defendant, right? So I want to sue somebody in Texas, but the person I want to sue is not in Texas. You can get general jurisdiction over that person if they have enough of a presence here ongoing that there's a reason to say that they are at home in Texas, even though they don't reside here. That's general jurisdiction. Or if they just have the certain minimum contacts with Texas, and my lawsuit arises out of those contacts, then you might get specific jurisdiction over that out-of-state defendant because the contacts that they had were purposeful, and my claim arises out of those contacts. You remember, right? All that law school exam question. So the case in Ford, this is the other thing, is the trend here has been toward closing the courtroom doors. The trend has been toward narrowing the grounds for personal jurisdiction, making it harder and harder for out-of-state defendants to get sued in a state where they don't have sufficient contacts, right? So over the last, I think it's 20 years, and it actually might be longer than that, every personal jurisdiction case that has come before the court has gone in favor of the defendant not being able to be sued. In other words, no personal jurisdiction because whatever the contacts were, they weren't adequate to establish jurisdiction. Every single case for like 20 years, no jurisdiction. So that's the trend at the court. This case comes up, and what happens is it actually arises as two cases. One's in Minnesota and one is in Montana. And they involve auto defects for Ford cars. But in both of these cases, the person who was injured, the plaintiff, they didn't buy their car in the state, right? The person in Minnesota, let's say they bought their car in Wisconsin and then they moved to Minnesota or something like that. Person in Montana, they bought their car in, Idaho, and then they moved to Montana. So the car was not manufactured in the state and it was not sold in the state. It wasn't purchased in the state. The car that has the defect doesn't have any connection to the state other than that's where it was when the defect caused the injury that it caused. And so Ford says, we don't have contacts with the state to give the state jurisdiction over us as a defendant. We didn't make our car there. We didn't sell our car there, et cetera, et cetera. And because their claims arise out of the defect in this car, the claims don't arise out of any contact we have with that state because that car wasn't manufactured or sold in that state. They need to go to the state where they bought the car or something like that. So again, the trend at the court is everything we can do to narrow personal jurisdiction. So everyone watching this case thinks the court's going to say, yeah, no jurisdiction, no contacts. Instead, the court says, come on, guys. You market that car in that state. You sell hundreds of those cars in that state, just not that car in that state, right? But you do sell that car, just not that one. And all of what you're doing in the state is contact with the state that is purposeful, and that's enough so that you can be sued for stuff that happens with those kinds of cars, even if that particular car wasn't purchased in the state. So somewhat surprising, first decision in decades, literally, that the court has ruled in favor of the plaintiff on the personal jurisdiction issue. It's 8-0 because it's one of the cases that was argued before Barrett got onto the court, so she doesn't participate, but it's a unanimous court saying this. The most interesting thing about this case, besides being a trend bucker, is Justice Gorsuch writes a concurring opinion where he says, I kind of think we need to reconsider all of personal jurisdiction doctrine and the whole distinction between specific and general jurisdiction has gotten so muddy, and I'm not sure about how this is developed, and really we need to take a hard look at this. And I think Justice Thomas joins him in that concurring opinion, but it's a pretty interesting opinion, and it's not the first time that justices on the court have suggested that maybe this doctrine's a little messed up. And he relies on some originalist arguments for this as well. I will mention we have a case. We just filed our reply for a cert petition about personal jurisdiction issues. We absolutely played hard to Justice Gorsuch's concurring opinion. Hey, this needs to be cleaned up, right? Because there's some problems here. So we'll see how that goes. I just filed the reply brief yesterday. All right, Fourth Amendment. So Fourth Amendment involves search and seizure. All the best stories are in the criminal cases, right? The Lang case, so the Fourth Amendment right against unreasonable searches protects your home, right? And it includes the curtilage of your home. An officer cannot even enter the curtilage of your home, which is the area immediately outside your home. An officer cannot even enter the curtilage of your home, let alone your home itself, without that being a violation of the Fourth Amendment right against an unreasonable search. Just entry alone is a violation. They've got to have a warrant, or they've got to have consent, or, well, that's about it, really. So there is this exception, which we call exigent circumstances, which basically means it's an emergency, right? So, for example, an officer has good reason to believe someone inside is dying and in need of assistance. So they go rushing into the house to help that person. That would normally be a Fourth Amendment violation to enter the house without a warrant or without consent, but it's exigent circumstances, right? Someone's dying, they need to be able to go in and help. So we have this exception that the court has created. The question in this case, Mr. Lang is driving home and he's playing some loud music. He's attracted an officer's attention. And the officer starts following him. And he reaches up at one point and turns the overhead light on in his car. And the officer follows him all the way home. His garage door opens. He pulls into the garage. The officer pulls over and runs in. The garage door is shutting, and the officer, stops the garage door from shutting and goes in, does a breathalyzer, finds out he's been drinking, arrests him for drunk driving. Now, it's really important to understand he didn't have any reason to think he was drunk other than I think he might be drunk, right? But he's not driving erratically. He's not doing any of the things that you normally would think he's drunk about. But he did turn that overhead light on, okay? The officer goes into the garage, does all that, and he challenges us and says, you entered my house without a warrant, without consent, and there's no exigent, there's no emergency. And the officer's argument is, I was in hot pursuit of someone who had committed a misdemeanor, because in California, it's a misdemeanor to turn the overhead light on in your car. So the argument is, I'm in hot pursuit of a misdemeanant, and that's an exigent circumstance for me to run into the house and pursue and arrest this misdemeanant. You're all laughing, but so that's the question. Does hot pursuit of a misdemeanant qualify as exigent circumstances to create the exception against Fourth Amendment protection for officers entering your home? The court says unanimously, no, hot pursuit of a misdemeanor is not always going to be exigent. That's what the officers were arguing. Anytime we're in hot pursuit of a misdemeanor, we should be able to do this. The court says no, but sometimes maybe. So the court's answer here is unanimously, it's going to depend. What's the nature of the misdemeanor that we're talking about? Because there are some misdemeanors that actually might have some seriousness to them, right? So it's going to be pretty fact specific in these cases. There might be exigent circumstances in some cases, depending on what the misdemeanor is and what the facts are and what exactly is happening, blah, blah, blah. But it's not going to be that way in every case. And he turned the overhead light on. I mean, come on. So that's the answer. Pretty interesting case for Fourth Amendment stuff. And we don't actually get a super clear answer, just it's going to depend every time. The next Fourth Amendment case is about the seizure side of the Fourth Amendment. The entry into the home or the curtilage is a search issue. The seizure side of the Fourth Amendment says you can't be you're protected against unreasonable seizures, right? And this is where a lot of times excessive force claims fall under the seizure part of the Fourth Amendment, because if you're being seized in a way that is excessively forceful, then that might be a violation of your Fourth Amendment rights. What happens in this case is Ms. Torres was sitting in her car and the police officers approached her. I think they were going to serve some kind of warrant on her, but they approach her as she's sitting in her car and she doesn't want to be approached by the police officers. So she drives away. The police officers, of course, start shooting. And she is hit. She's hit like 2 or 3 times by the police officers' bullets. And she drives like 40 miles and ends up at a hospital, and she's okay. But she says this was an unreasonable seizure, right? Excessive force. You can't fire a gun at me just because I'm driving away from you. The officers say, there's no violation of the Fourth Amendment right against unreasonable seizures because you got away. We didn't seize you. Yes, we fired a gun at you. Yes, we hit you 2 or 3 times, but we did not succeed in seizing you. So there's no seizure for you to claim unreasonable seizure. So that's the question in this case. Is the application of force with the intent to seize somebody, is that a seizure, even if they get away? This was like anybody's guess. Like, who knows what the court's going to do here, right? The court, in a 5-3 opinion, where Chief Justice Roberts and I believe it's Kavanaugh side with the 3 liberal justices, say, yeah, this counts, right? The other 3 conservatives, and this is another 8 justice. Justice Barrett was not yet on the court when this case was argued. The other 3 conservatives say no seizure, right? They didn't seize her, so no seizure. But 5 justices say, yeah, the attempted seizure is a seizure, even if they don't succeed in seizing. But this is only just the question of, does this count as a seizure? It's still going to go back down, was it unreasonable, right? And then we're going to have questions about, well, qualified immunity, right? Maybe the officers made a reasonable decision in the moment. So it doesn't mean her rights are vindicated. It just means it counts as a seizure. She can go ahead and claim it's a seizure, but the officer still might be exonerated. I'll mention one more. I think this is probably the last one. We have a case at the Fifth Circuit right now involving a pro bono case, a knock and talk. Knock and talk is another exception to that Fourth Amendment protection of your home. Officers cannot even enter the curtilage of your home unless they have a warrant or consent, with the exception of a knock and talk. Like any other citizen, they could walk up to your front door and knock on the door and talk to you and ask you some questions. In this case, the officers decided to do that at 2 a.m. And at 2 a.m., they went up and knocked on the door and then started pounding on the door and then started pounding on the window until the people inside finally came to the door. And it resulted in a forceful arrest of the person on the front patio. And the question is a 2 a.m. knock and talk like that within the exception of the knock and talk that we usually allow for the Fourth Amendment? Another case that has really interesting Fourth Amendment implications, maybe Supreme Court potential. Lots of interesting stuff going on at the Fourth Amendment, always, every term. All right, First Amendment. This case involves a city ordinance in, I think, Philadelphia. Yes, where the city has an adoption program and it partners with other organizations to run this adoption program. And the ordinance says that these other organizations who are participating in the adoption program, they cannot discriminate based on race or religion or gender or sexual orientation when they're placing kids for adoption, right? And it's just a city ordinance. It applies to everybody equally, and no organization that participates in this program can discriminate. I believe it's a Catholic organization, challenged the ordinance saying, we don't, it's against our religion to place children with same-sex couples. So we don't want to do that. And the ordinance, if the ordinance is requiring us to do that, it violates our religious free exercise rights under the First Amendment, right? And there's this old case that some of you might remember called Smith. And in Smith, the issue was Native Americans were smoking peyote for their religious practices. And there's a federal law that says you can't smoke peyote because that's a criminal drug. And Justice Scalia wrote the majority opinion in Smith, which says, if you have a neutral law that applies to everybody equally, the fact that it has an impact on a religious group does not necessarily violate religious rights unless you can say somehow that the law was targeting the religious group. If the law is neutral and it applies to everybody equally, then there's no violation of the religious right just because some religion wants to do something that the law outlaws. That creates a big problem for the Catholic organization in this case, because this city ordinance in Philadelphia is a neutral law written. It applies equally to everybody. They're not targeting religious groups. They're just saying, hey, nobody can discriminate on these grounds if you're going to participate in this program. So the challenger says, not only this violates our rights, but also you need to overturn Smith, because the only way we're going to win here is if you overturn Smith. So that's the question in this case. It's not just about the First Amendment, but also about precedent, stare decisis. How do we handle precedents that maybe some people on the court don't like? The court says unanimously, this does violate the organization's religious free exercise. So even the liberal justices join in and say this does create a problem for religious free exercise. On the question of should we reconsider Smith, the court says, no, we don't have to reconsider Smith. That's weird, okay? It's really hard to reconcile how do we reach the conclusion we've reached and not reconsider Smith. But the 6-justice majority that says we don't need to reconsider Smith includes the liberal justices who like Smith. There are conservatives on the court who don't like Smith. The dissenting justices are Justice Gorsuch, Justice Alito, and Justice Thomas, who all think we really ought to overturn Smith. There is some speculation here that the way that Chief Justice Roberts gets the 3 liberal justices to agree to the unanimous holding that this violates free exercise is by also agreeing with them that we don't have to overturn Smith. So there's some speculation about a little horse trading going on in this case, where you get 2 outcomes that satisfy different components of the court in a way that the overall outcome is weird, because it's really hard to reconcile the outcome here with Smith, but they did it somehow. All right, the next big First Amendment case. This is, some of you might have heard of this as the cheerleader case. So backing up, there's the case Tinker, right? Another law school case. Probably most of you heard of Tinker. This is the case where the high school students are protesting the Vietnam War with black armbands. They wear the black armbands to class. They get disciplined. And the Supreme Court says, hey, students, minors at school, they have First Amendment rights. And unless you can show that like they're somehow disrupting class or they're disrupting school activities, unless there's some reason like that you need to squelch what they're doing, they have free speech rights that are protected at school, and they can wear these armbands. Okay, that's what Tinker says. Now, in this case, the cheerleader, I think she's a sophomore at the time, she tries out for the varsity cheer squad. She doesn't make varsity. She's still on the JV. She's still going to be on the JV squad, but she doesn't make varsity, and she's not super happy about it. So she goes on Snapchat, and she shows a particular finger while using a particular word that starts with the letter F, and she says, F cheer, F the coach, F the school, F all this, and it's this little, however long the Snapchat video is, and she's got like 200 followers. But knowledge of this video makes its way back to teachers and coaches at the school, and she gets, I think, suspended. I don't think she's kicked off the team completely, but she's suspended by the coach from the cheer squad. She says, hey, I have First Amendment rights. And there's a lot of case law, nothing stops you from using the F word, nothing stops you, free speech rights are pretty robust. But the question here is, what kind of rights do minors, students have in the context of school and school activities? Because cheer is a school activity, but there's this complication that this is speech that occurs off campus or online. It doesn't occur at cheer practice, right? She's not disrupting cheer practice itself. She's not disrupting a football game during, halftime when the cheerleaders are out there. She's not doing something disruptive at school, but she is doing something that is arguably disruptive. And the question is, where is the line for First Amendment protection for students in school, in activities related to school stuff? And what can teachers and coaches and people like that do to discipline students for stuff when they do this kind of stuff? Really interesting First Amendment problem. And how does Tinker apply, et cetera, et cetera. The court says 8-1 in an opinion by Justice Breyer. Yes, Tinker extends to off-campus speech, including online speech. So they do have First Amendment protected rights, but it's going to be fact specific again, because we're going to say, in a lot of situations, the First Amendment protects the student's speech, and teachers and coaches, they can't discipline speech, except there might be situations where it is actually disruptive, even if it's off campus, even if it's online. For example, online bullying, right? We might want to say that teachers or principals and coaches can discipline students who are bullying other students online, even though that's not happening at school. That can be disruptive for what's going on in the classroom or what's going on in whatever the school is in charge of. So Breyer basically says they have free speech rights. That's protected. They can't be disciplined just because they said something, but there might be situations where they could be disciplined. So another interesting First Amendment case. All right, moving on to the Eighth Amendment. How am I doing on time here? Okay, so Justice Kennedy, as the swing justice, one of his sort of legacies at the court was siding with the liberal justices to do a lot to try to protect juvenile criminal defendants, including eliminating the death penalty for juveniles. There are several opinions where he sided with the liberals to say, look, we need to be a little more circumspect about how we handle juvenile criminal defendants, trying to cut back on not just the death penalty, but life without parole for juveniles, stuff like that. This case, the Jones case, is the first case involving juvenile criminal defendants that comes up without Kennedy on the court, and with no longer have Kennedy plus 4 liberals to rule in favor of a juvenile defendant. So the question is, what's going to happen in this area of juvenile criminal defendant law without Kennedy and without the 4 liberals to join Kennedy? What's the direction of Kennedy's legacy in this area? What direction is it going to go with the new Roberts Court? The actual question here is, Jones is sentenced, I think he's, I want to say 15. He's sentenced for life without parole, and in the record, it just shows that the judge considered his age. That's all it says. And the question here is, does there have to be more than that before you sentence a 15-year-old to life without parole? Do you have to make some kind of finding, some kind of factual finding that says this person is incorrigible, unrecoverable, they will never, there's no basis for ever giving them parole in their entire life? Do you have to make some kind of finding like that before you impose the life without parole sentence on a 15-year-old? Or is the fact that the record just shows the judge considered his age, is that enough? The question goes up to the court, and it's a 6-3 decision, the 6 conservatives and the 3 liberals in dissent. And the court says, no, you do not need some kind of special finding about incorrigibility or they're unrecoverable or unrehabilitatable or whatever the word is. If it shows in the record that the judge considered the defendant's age, that's all that is needed, and the life without parole sentence is fine. Big decision under the 8th Amendment for juvenile defendants, and a big signal that whatever direction the court was going with Kennedy there for juvenile defendants, it's not going that direction at least a big signal that it's probably not going any further in that direction. So that's another big case that sort of signals the shift on the court. The Affordable Care Act, I don't know, are you guys all tired of hearing about cases about the Affordable Care Act? This has been going on for like a decade. So as you probably recall, when the Affordable Care Act was passed, there was a challenge to the mandate, right? And the mandate came with this penalty. If you don't have health insurance, the individual mandate says, if you don't have health insurance, you're going to pay this penalty. And this was one of the parts of the Affordable Care Act that sort of strongly encouraged everyone to get insurance, right? And it was challenged. It goes up to the court. They challenged the individual mandate. I don't know if you remember all the talk about broccoli and stuff like that, but the idea that, well, could the government make you eat broccoli because it's good for you? And, if they can't do that, then they can't make you get health insurance. So the challenge to the mandate and whether that was constitutional goes up to the court, and the court says the mandate is constitutional because it is a tax. You remember this? I think we actually talked about it like right here in this room. Chief Justice Roberts is the one in the majority on that opinion, and he gets the conservatives excoriate him for siding with the liberals to save the mandate. But he says it's a tax and Congress has power to tax. So there's nothing wrong with the individual mandate because they're just basically imposing a tax if you don't have health insurance. Well, what the Republicans in Congress did in response to that is they passed an amendment to the ACA that zeroed out the penalty. So now there still is a mandate. It says you have to have health insurance, but there's no penalty if you don't. So there's no tax. And so the challenge, they bring this new challenge. It says, if there's no actual penalty, then there's no tax involved. Now, is the mandate unconstitutional? Can Congress tell you you have to get health insurance if they're not taxing you for it? They're just telling you have to. Is that unconstitutional? And there's this added question of, if it's unconstitutional, does that mean the whole ACA has to be stricken as unconstitutional? Or can you sever that mandate part out and save the rest of the law? Their argument was, there's no non-severability clause in the ACA. So their argument was the mandate is unconstitutional because it's no longer a tax, and you can't sever it out from the rest of the law. So the whole ACA has to be stricken as unconstitutional. And Texas, along with some other states, are the ones who bring this lawsuit. The Trump administration decides not to defend the ACA, which normally the federal government would defend a federal law. But the Trump administration says we're not gonna. So California enters the case with some other states to defend the law. A new question arises. How does Texas or these other states who are bringing this lawsuit, how do they have standing, right? Remember standing? How do they have standing to bring this lawsuit? Because it's not Texas who faces this individual mandate, right? The mandate is aimed at individuals, not states. So those are all the questions before the court on this new ACA case. When Biden gets elected, the case gets argued, and then Biden gets elected, and Biden's new Solicitor General sends a letter to the court and says, by the way, we no longer take the position that the Trump Solicitor General took. We actually would defend the law. We take the position that California takes. Doesn't really matter because the case has already been argued, but he's just signaling we're changing positions from where the Trump administration was. This is all, by the way, highly unusual. Right? It's really unusual for the federal government to not defend the federal law in the first place, and really unusual for the new administration to have to come in and say, we change our position from the previous administration. It's just weird. But, the last 4 years were weird. So this is what happens. The court says 7-2. Justice Breyer writes the opinion. I don't think they have standing, right? I mentioned both the conservatives and the liberals will use standing if they don't want to have to answer all this stuff. And that's what they do here. They say, I don't think states have standing to bring this lawsuit. But there's also a really strong signal in this case. We're done hearing cases about the ACA, guys. We're done, okay? Stop bringing lawsuits about the ACA. No more, we're done. So I think this is probably the last case that we'll hear about the ACA. Last but not least, the voting rights case, Brnovich. So if you remember a few years ago, there was a case called Shelby County. The Voting Rights Act has Section 2 and Section 5. Those are the two big sections for enforcing voting rights. Section 5 was the section about pre-clearance for states, and anytime states are going to pass laws that restrict voting rights, the states have to go through this process of getting pre-clearance for those laws. And if they are passing laws that restrict voting rights, under Section 5, you had these really strong tools for attacking those laws that restrict voting rights. Shelby County was a case a few years ago where the Supreme Court essentially gutted Section 5. Essentially said, look, until Congress does some things to update the Voting Rights Act, Section 5 is essentially useless. So no longer do people looking to protect voting rights have Section 5 as a viable tool. The only other section is Section 2, and Section 2 it takes aim at laws that have, like a disparate impact. Obviously, a law that is explicitly, if a state passed a law that says, black people can't vote, we're going to have a problem. But Section 2 also says if you pass a law that has a disparate impact on certain communities, then that also might be a violation of the Voting Rights Act. So if you pass a law and it doesn't say, Catholics can't vote, it doesn't target a group, but the impact of the law is that these communities who are already, potentially disadvantaged communities, they are going to be further disadvantaged by this voting law, then that could violate Section 2. That's the only tool left, and this case challenges that. What happens here is Arizona passes a law, and it has two components to it. The first one is this out of precinct policy, and what it says is if you vote at a polling place that is outside your precinct, your whole ballot gets tossed out. Now, the reason this is a big deal is you might, on your ballot, you might be voting for a bunch of things that have nothing to do with what precinct you live in, like governor, right? It doesn't matter what precinct you live in or what precinct you vote in, everybody votes for governor. But if you vote at the wrong polling place, your whole ballot is tossed out. And this has the argument from the plaintiffs is this has a disparate impact on certain communities, particularly poor and racially minority communities, because those tend to be the communities where they shut down polling places or where they provide the fewest number of polling places. They also tend to be, especially the poorer communities, they tend to be the lesser educated communities, or the communities where you have single parents or two parents who are having to work, and so getting to a polling place is more difficult. Maybe they have to rely on public transportation. Also, when I say less educated, I don't mean school. I mean they might not be getting information about where the proper polling place is, because that kind of communication, that kind of dissemination of information is not as good in poorer areas as it is in wealthier areas. So these people might go to the wrong polling place. And if they go to the wrong polling place, either because they don't have enough in their area or they were misinformed about where to go, their whole ballot gets tossed out, right? So the argument here is this is a violation of Section 2 of the Voting Rights Act because it has a disparate impact on these communities. The other part of it, the law, is against what they call ballot harvesting, which is a pejorative term, but what it really means is you can't have groups who are trying to help people vote who will go around and collect absentee ballots to help make sure they get mailed, right? Again, certain communities are affected by this more than others because, again, access to things and information about things. And there are these organizations who will try to help those communities get their votes cast by going around and trying to help them get their votes mailed. And Arizona says you can't do that. No more doing that. And the argument is that has a disparate impact on certain communities. So that's the challenge that goes up under Section 2. The court says in a 6-3 decision, again, we're not going to get a lot of 5-4 decisions, not as many anymore. They're going to be 6-3. It's the 6 conservative justices and the 3 liberal justices. Justice Alito writes the majority opinion. He says, this does not violate Section 2 of the Voting Rights Act. These restrictions on voting are perfectly fine. And by the way, here's what you need to be able to show in order to have a Section 2 challenge to a voting rights law. And he basically raises the bar. His opinion says, in order to bring a challenge under Section 2, you can't just show disparate impact, because every law is going to have a disparate impact. So some disparate impact is not a big deal. That's not going to be a violation. You have to show something bigger. So in the same way that Shelby County essentially gutted Section 5, but the Brnovich case essentially guts Section 2, makes it extremely difficult to bring challenges under Section 2. Really, really huge case in terms of how our voting rights work, how our voting rights are protected, et cetera, et cetera. Big, big deal. Probably the case that's going to have the biggest long-term impact of any of the cases. The same way Shelby County had a pretty scathing dissent, this case has a pretty scathing dissent about what are you doing here, right? the only way to fix either of these, the Shelby County or the Brnovich case, the only way to fix either one of them is to pass legislation updating the Voting Rights Act. That's why you may have heard in the news, there's a lot of talk from the Democratic side about trying to do that right now. That's why there's all that talk. It's because of Shelby County and the Brnovich cases. That's why they're talking about trying to update the Voting Rights Act. It comes straight out of the Supreme Court decisions. All right, that's it for cases we're talking about from last term. This term, some of you might have heard there was a case argued this morning called Dobbs. Lots of big stuff coming up. Again, we're in a new era, right? We're in a new era with a court that has 6 strong conservative votes. It is essentially the Warren Court, but for the conservative side, this new Roberts Court. And that's why we're seeing these cases being brought, because people saw the writing on the wall. They knew which direction the court was going. So they immediately started doing things to bring these issues up to this new court to see what the new court's going to do with them. The biggest one, at least right now, is abortion. We have a new law here in Texas that you might have heard about. That case is also before the court. It's up before the court on preliminary injunction stages of the litigation. The Dobbs case is up before the court more firmly on the merits of the case. The court's going to decide both the Dobbs case and the Texas case at some point, probably not till the last day of the term, because they're going to wait as long as possible, I think. It is a very significant chance that Roe versus Wade will be overruled, or at least a not insignificant chance. The other possibility is the court will do something to Roe versus Wade and Planned Parenthood versus Casey, similar to what they did to the Voting Rights Act, right? You basically make it so that those precedents don't have a whole lot of traction or value. It's basically what they did to Smith when we were talking earlier, right? We're not going to overrule it, but we can basically rule in ways that ignore it. So all eyes are on the court. Again, the Dobbs case was just argued this morning. All eyes are on the court, what they're going to do about abortion. It's going to be really interesting, particularly because they're going to issue this decision sometime next spring or early summer, and we're heading into elections, right, for 2022. So the impact that the court's decision has on elections is going to be big. Lots of big stuff. There's some other stuff up here. I won't go through all of them, but big Second Amendment case, some other First Amendment cases. There's also, I don't know if you guys remember, there was that big case called McGirt a year or two ago. I think it was just not this last term that we talked about, but the term before that, where like half of Oklahoma was ruled Indian territory. Remember that? Big case in Indian law. And of course, what it did, it had to do with criminal jurisdiction, and the state basically says the state doesn't have jurisdiction for criminal cases. The only jurisdiction is under federal law or tribal law, because this is Indian land. So half of Oklahoma. So obviously what happens there is everyone who is convicted in state court under state prosecutions comes and says, whoa, you could not prosecute. You had no jurisdiction to prosecute me. So there are already petitions before the court about, was McGirt retroactive? Now, or is it procedural? That's exactly the question. Now, again, Justice Gorsuch wrote the opinion in McGirt, and he makes it sound like from the beginning, under these treaties, under the originalist readings of when these treaties were passed and signed, this is Indian land. So it sounds pretty retroactive, right? But the court could take one of these cases and say, yeah, we don't think it's retroactive. So going forward, that's Indian land, but none of those prosecutions and convictions can be challenged looking backward. Who knows? There also is a case that's brought that says, I just think you should overrule McGirt. So even though McGirt was just issued like 2 years ago, it's already being challenged as a precedent that should just be overruled. And the only reason anyone brings that challenge is because they know the court's different. A lot's changed in 2 years. It's now a new court. And Gorsuch, who sided with the 4 liberals to issue McGirt, no longer has four liberals who are going to defend his opinion. He's got 3 versus 5 other conservatives. So the McGirt stuff is percolating. There's also right here out of Texas, the Indian Child Welfare Act law, which is about adoption for Native American babies. The constitutionality of that has been challenged here in Texas, and that's before it's almost for sure going to get granted at the court. All kinds of really, really huge cases for this term, and it's the first full term with Justice Barrett on the court and the whole new era, new Roberts Court era. That's all I got. Anybody got questions?
Can you talk a little bit more about the shadow docket.
Shadow docket.
Because it seems like everything's now going to the shadow.
How many of you have heard of the shadow docket? Yeah, so this law professor came up with this term, the shadow docket, and now it's like the new catchphrase. I'm real concerned about that shadow docket. So all the shadow docket, it's not a new thing, right? This is just, it's a new name for a thing that's always existed. The shadow docket is everything the court does that is not the decisions we just talked about. So when the court issues a decision without hearing full briefing and full argument on that case, that's the shadow docket. When you get a last minute request for a stay of execution from a death penalty defendant, and the court decides whether or not to stay the execution, that's the shadow docket, right? Or when you have a case where an injunction is imposed, and then there's a challenge, they want to stay that injunction, and then whatever the circuit court does with that injunction, that goes up to the Supreme Court, and the Supreme Court has to decide whether to lift or stay the injunction. That none of that's happening with like full briefing and oral argument. It's not like a normal merits case at the court. So that's the shadow docket, and they call it the shadow docket because nobody even is aware that this is happening, right? It's just the court is doing all kinds of stuff every day, and most of us are not paying attention. We don't really realize the court's doing all of that. Everybody knows about the big headliner cases, and maybe they know, oh yeah, I think there were maybe 70 cases actually. But very few people know about all the other stuff the court is doing. That's the shadow docket. It's always been there. It's gotten a lot of attention lately, not just because of the catchy new bumper sticker kind of name for it, but it's gotten a lot of attention specifically for qualified immunity cases, because those cases have been getting into the news. You might have heard about this. Qualified immunity is a doctrine. It protects all government officials, but in some very controversial ways, it protects police officers. So when police officers do things that maybe they shouldn't have done and people try to sue them for it, they very rarely are held accountable because of qualified immunity. And a lot of those qualified immunity cases, they get to the court on this shadow docket where someone files a petition. They want the court to hear the full case and argue the case and issue a full decision, but the court doesn't. Instead, it just summarily reverses whatever happened below and says, nope, qualified immunity. And so these qualified immunity cases are happening sort of in the shadows on the sidelines where they don't get a lot of attention. But people are trying to shine a light on that specifically because of the qualified immunity cases. That's why the shadow docket's getting a lot of attention. It's because a lot of that qualified immunity stuff is happening over there. So I don't know if is that the more you wanted me to say?
The whole OSHA, ETS and everything, that's going to be up on the shadow docket probably.
Yeah, the vaccine mandate, which has been issued, it has gotten to the court basically in those kinds of procedures that are where a decision is going to be made that is going to sort of be that shadow docket kind of decision. It won't be the merits cases like the ones we discuss every time we do these presentations. So it is a big deal. The court does tons of, the death penalty is another area where tons of stuff happens with the death penalty, and it happens in that shadow docket where there's not full briefing, there's not oral argument. It's just, there's some emergency briefing, and then the court decides something and nobody really hears about it unless you're paying attention to the death penalty. So it's a big deal, and it is getting more attention now, but it's always been there. It's not a new thing. So any other questions?
So do you see any cases making their way to the court related to civil asset forfeitures?
I'm not aware offhand of any petition currently before the court on that issue, but that is another issue similar to qualified immunity, where you are seeing people on both political sides. So qualified immunity is an issue where you're seeing liberals and conservatives saying, we're getting a little concerned about this, right? We can't hold police officers accountable for stuff. The asset forfeiture issue is another one of those issues that's been getting more and more attention, and you have people on both sides interested in it. So there's a lot of signs of potential movement on qualified immunity because of interest on both sides. Same thing for civil forfeiture. I think there is building momentum for the court to maybe do something about that, but I'm not aware of a petition right now involving that issue. So there probably are some. I'm not aware of them. There's 8,000 to 10,000. I'm not reviewing all the petitions at the court. So, any other questions?
Is the disparate impact comments from the voting rights going to have application beyond voting rights for like EEOC purposes or anything else?
That's a really good question. That's one of the reasons that decision is potentially even bigger than we think it is, because the rationale that Justice Alito uses for why disparate impact has to be bigger than what you're saying it is could be applied in other contexts. Now, he does say a lot of stuff that's specific to voting, right? He basically says, look, there's always going to be some hindrance to your ability to vote, right? So the fact that a state passes a law that increases the hindrance or has some kind of disparate impact, that's not, he's doing all of that very much in the context of voting. So there's an argument where you could say that's just specific to voting. That doesn't apply to disparate impact arguments in other contexts. But there's also an argument where you could say, well, the rationale still applies, right? So there are people who are worried that the impact of that decision will be bigger than voting rights. I mean, in my opinion, big enough already on voting rights, but it could be bigger. Any other questions? All right, thank you very much for having me.